Hey everybody, I'm immigration lawyer John Khosravi. Thank you for joining episode 240, actually episode 250. Got to change the title of the Immigration Lawyers podcast. I've been doing these Monday morning 6 a.m. shows. Today I'm switching it up. Instead of doing the top 10 things I thought about I want to share, it's going to be a focus on the Ombudsman's office, in particular, their 2020 annual report. The reason I want to make sure I get it is because I did a whole review. I prepared one for the 2021 report. 1 year goes by, I still haven't put it out. So it's like if I read the stuff and do all the work, I got to get it recorded. So I'm going to go over 2022. Maybe I'll reference 2021. Maybe I'll do a separate one, goes back into it, see how long this takes. So we'll do like that. But as we're talking live, I'm making corrections here. Unfortunately, you go live, that's the problem. Things happen that aren't always smooth, but hey, you got to do it. So while I'm doing that, I do want to remind everybody that the next episode, the new issue of the Immigration Lawyers Toolbox magazine is out. Wonderful issue, a lot of stuff in there that can help you make a better practice. Check it out at immigrationlawyerstoolbox.com/magazine. You find a great information there. I want to thank the sponsors for the magazine. DocWise is always a regular, DocWise.com. Form software, management software to become a better attorney, become a better firm. Check it out. You get additional 10% off your annual plan by going to docwise.com/immigration-lawyers-toolbox or podcast. We have two different codes, but podcast, and then use the code Immigration Lawyers Podcast. I just did the previous posting on this was an interview with the co-founder of DocWise, where he goes over the sale of DocWise. It's a big deal in our immigration community that there's money out there to buy these kind of softwares, by these venture capital firms. Or corporations, whatever. I don't know the details of the sale and stuff, but the stuff like that. But also, he updated on some really new features that have come in. So those are really good. These regular interviews I do with co-founder James Pittman about what updates there are in their software. I also want to thank Argo. ArgoVisa.com is their website. I may have just said Argo.com, unfortunately, in previous postings, but ArgoVisa.com is a great program. That what they do is they get former consular officers all together on a team, and you and your clients can schedule times with them, do practice interviews and brainstorm with them, all this kind of stuff to have an extra next level of service and prepare for consular processing, which, as we all know, is a minefield. You never know what you're going to deal with when you go in there. So it's good to have officers who see the behind the scenes aspects and can bring their personality and their perspective, not personality, but just have a sample of interactions that they've dealt with and do with you, so the client gets more comfortable. Because as we all know, clients also get really nervous. So it's good having a certain person. I sat in on one of these interviews, and at first it was nice. You're laughing, you get to meet this and that. And then once the consular mode turned on, we were doing like official practice interview. The attitude completely switched, which is good. So the client know, hey, this is a very serious affair, and this is how they go after you. Some of the questions like were just like random, like why are they focusing on this? But that's just how it is with consular. That's why ArgoVisa.com becomes really helpful in these kind of scenarios. I do want to mention a couple of housekeeping stuff that I hope you're listening to. One is, it's the big one. So I'm developing ILT, the Immigration Lawyers Toolbox, more. I had one software I was using. I had a new one I switched up to for create a community page, which has questions and answers. I post tips. I post like CLEs, videos, all this stuff on there. If you want to join that community, I'm starting out with people that are newer in immigration law. So if you're just getting involved, it's a great community page where I constantly give information and stuff, and we could ask questions. Email me at info@immigrationlawyerstoolbox.com. Some people had emailed me. I hadn't added you yet because I'm switching from the software called School to a software called Circle.so, and I'm just testing out the Circle.so. Probably gonna stick with Circle.so. It makes it more flexible. But if you emailed me, I haven't added you yet. That's the reason. But we're gonna be switching to that. I'm plugging the pages and populating it and all this kind of stuff. I think it's gonna be really neat. Have a place where all the videos, content, and community are there, plus all this other stuff. We can do live videos internally. We have a monthly office hours for our paid program that people can join there, watch it live instead of using Zoom. So it's all-in-one headquarters for that kind of stuff. I think it's going to be a lot of fun. So definitely check that out. And if you haven't already, like and subscribe. We have a YouTube page with all these videos plus clips, as well as Instagram for Immigration Lawyers Toolbox. Good place to go and visit there to get like a bunch of content. It's just there. And one note I forgot to say last time is my law firm, JK Law, is in growth mode. So next year or two, we're going to be hiring a lot. If you are listening to this podcast, it shows you care about immigration law. So please hit us up. Just let me know your resume, just we could talk or something like that potentially. I might not hire you now, but I'd rather have you in the system, my thoughts, so that when the need is there, I know who to contact. So that's it. So with that, let's get it started. So I was watching On the video portion, you're going to see a screen. I'm going through the Ombudsman's annual report for 2022. I've made notes on it, my digital note taker, and then I send it back to the computer. So you go through it. There's large sections about like Asylum and updating technology and stuff. Very briefly going to talk about that. Usually I talk about the stuff that affects the case that I handle, so it's important for me to know. So I'm going through it right now. The first problem, so there's a lot of different, let me give you an overview of what it is. So Ombudsman's Office is a group that is supposed to kind of review and help you with USCIS issues that pop up. They do great service. I got to give it to them. They try their best. So the case assistance and public engagement is really good. A lot of the stuff that they asked USCIS to do was actually implemented in the last year or two. I mean, some of it not, but a lot of it's hard for USCIS to implement because of the problems of staffing and delays and all that kind of stuff. But they are doing good, and they are getting things in, and even like helping cases. They help thousands of people every year. If their cases are stuck or something, they help them go through that. So they're really pushing on issues related to EADs, asylum delays, all this kind of stuff. So the first part I took notes on was increasing accessibility to legitimate travel advanced parole. As you all know, advanced parole has gotten out of control. They have switched it up where if you're doing adjustment of status, the EAD comes much faster than before. I get EADs for most cases in 4 to 6 weeks. I have one or two stragglers that haven't got their EADs, but it is what it is. But advanced parole is kind of like this thing that's just not even happening now that EAD is less of a priority because they're giving it out. And so they're saying USCIS should consider the following recommendations. So I want to mention the recommendations they're making because they're interesting. They're things I've thought about. But they say to reduce barriers to travel, enable USCIS to better manage the process of providing advanced parole documents or APDs to those who need them the most. One, authorize the advanced parole incident to the filing of Form I-485 and upon providing biometrics to USCIS, thereby eliminating the need to file Form I-131 and allowing for travel. So they're going to talk about this in other parts. Like there's no exact statutory language that says you need to have advanced parole per se. So it's more of an internal regulatory thing that popped up. And they're saying just why not give it incident status? What difference does it make? And then they go into especially if you don't have like court removal or something like that. And then they say change the adjustment of status abandonment provisions such as they only apply to applicants who are not under exclusion. So they change adjustment status abandonment provisions such that they only apply to applicants who are not under exclusion, deportation, removal proceedings, and who leave without a receipt notice evidencing advanced parole. So you're just saying you just need a receipt. Extending the validity of advanced parole for individuals with pending I-485 until USCIS renders a decision on the Form I-485 or to coincide with current processing times. That's great. Stop considering pending I-131 for advanced parole to be abandoned by travel. So they're just really pushing the idea that it should just be filing advanced parole. It should be enough, or just auto, which makes total sense. This whole system right now, they have this whole bureaucracy around I-131s, which is not needed. And then they get into expedite processing. They're saying there are times when applicant or petitioner may need a decision of USCIS sooner. They should say, and we're going to go into all these in more detail, but essentially establishing a centralized process, creating a new form potentially for submitting expedite requests, because right now it's so all over the place, and developing standardized guidance of other requirements because it's so inconsistently adjudicated. Next, they go into initiating a discussion of ways to address the affirmative asylum backlog, and I just want to note here, the asylum backlog has grown to more than 430,000 pending cases. This is affirmative asylum with USCIS. Devastating impact on asylum seekers. And then they're saying, I should identify and group cases to increase efficiencies in interviews and adjudication. So imagine you have a bunch of Venezuelan asylum cases, just batch them up and do them together with one person. But that one person or one group is doing it has a negative perspective on it. It could ruin a whole lot of people. So there's a negative side to that too. But batch and group and then deprioritize non-priority applicants, such as those who have other forms available. So really just getting better at what they're doing and organizing the data. And then they say consider specialization, interview waivers, and that's going to be interview waivers for asylum, and simplifying final decisions as a way to increase case completions while supporting the welfare of officers and applicants. And then eliminating barriers for obtaining proof of employment authorization for asylum applicants. USCIS often denies employment authorization documents, work permits, filed by eligible defensive asylum applicants because it cannot find evidence of the pending asylum application in its systems or EOIR systems, which results in applicants having to submit multiple filings and endure extensive processing delays while attempting to resolve the issue. Meanwhile, those granted asylum by an immigration judge are instructed to call the USCIS contact center to request an appointment at their local field office, so an InfoVAS appointment to get an I-94. However, because of COVID restrictions, contract cuts, other measures taken by USCIS in response to financial challenges, they've made customer service difficult. And so it just goes into how much of a mess it is to try to get that done. They also say provide guidance to officers on how to contact EOIR to resolve discrepancies for this issue, and also designating an immigration judge order granting asylum as acceptable evidence for Form I-9 employer verification. So it says the judge approves it. You have the paperwork for I-9. Now the judge, it's like an unofficial thing. I mean, it's official, it's stamped and stuff, but you know how it looks like with EOIR. I mean, if you've seen it, so that may throw off some certain employers, and people could probably make fraudulent versions of that as possible. How do you go to verify that? But whatever you can, because if you got asylum, you got to work and stuff. It's not an easy thing to do. So we're going to go over a couple of the ones with regards to EADs, advanced parole, and one other thing. Not going to go into the asylum portions. But I guess the first section they talk about is called the Avalanche Impact of Backlogs 2021 in Review. They say blah, blah, blah. It also impacts supporting functions of contact center, congressional. So the backlog has really affected like the contact centers, congressional help, the ombudsman's office. Ombudsman's office saw a 79% spike in requests and case assistance in 2021 over the previous year. On the footnote, they say the CIS Ombudsman received 14,618 requests for assistance in 2020, but in 2021 they received 26,000, almost 27,000. So it's about almost doubled up of how much stuff they're requesting. They say it is important to note that the agency distinguishes, and this is how USCIS defines backlog, so it's important to see the definitions. It is important to note the agency distinguishes between what it considers a backlog and its total pending caseload. The agency's total caseload is not its backlog. Rather, it generally defines a backlog as a portion of its total inventory of pending cases that is outside processing goals for that type of form. And then, importantly, until very recently, the last time USCIS articulated processing goals was 2007. So, the way the record keeping, the analysis of the records, all this kind of stuff, it's all skewed and doesn't make any sense. But, that's what we're dealing with here with the agency. They say they've updated it, but as you all know, processing times are out of control. USCIS has come out and they said that a lot of cases are trying to put a 6-month time frame on it for this fiscal year. By October, that's going to be fixed. Who knows if that's actually going to be the case? But that's just the way it is with these agencies. So another part they say limits on the number of employees. Oh, this is for the F-400 naturalization, which were hugely delayed for some cases. I had a case, we had the interview. It took 6 months and a threat of a lawsuit to figure it out. But they say limits on the number of employees allowed to access federal record centers are limited. Also limited the transfer of files that USCIS needed to complete adjudicating for F-400 application for naturalization and other forms until a backlog of over 300,000 files had grown, leading to additional delays in application internationalization adjudications. Fewer appointments at application support centers for biometrics create a backlog of 1,000 applicants remaining incomplete as well. So for those who don't know, they put a bunch of files that were in storage in this mountain or something like that, and they wouldn't let people in there because of the COVID restrictions. So all these cases couldn't get adjudicated because for naturalization, you have to have the complete A file together before it's finalized. And so they couldn't get the complete A file out, give it to the field office, and so these cases got stuck, and it created unnecessary delays in people getting citizenship. And they talk here another part about it, about the effects that has with regard to filing for your parents or something like that, getting certain benefits, being able to vote. The consequences of the backlog for citizenship really affects a profound effect on the American people. Director Jadu of USCIS acknowledged that as of April 2022, the inventory of unadjudicated applications and petitions stood at 8.5 million, with over 5 million pending beyond processing times, published processing times. And for those watching, hearing on audio, they have a chart here. In fiscal year 2015, the pending inventory was 3.2 million. In fiscal year 2021, it's over 8 million. Just the first quarter is 8.5 million. So when you're, I'm gonna take this chart and make images of it and probably put it out. So I'm gonna put out these infographic charts and stuff like that. I'm gonna share it, and then you guys can send it to clients. So when they ask, why is my case taking so long? What's going on? You're being a bad lawyer. You said, hey, look, here's Immigration Lawyers Toolbox, independent organization, and this image is from Ombudsman's office, so it's like government information. Look, 8.5 million case backlog. So our pending inventory, that's the technical term, pending inventory. So that helped won't calm the nerves of clients, but at least know, hey, this is what we're dealing with. And this is where they say delays lead to increases in requests for assistance from congressional offices and the CIS Ombudsman. in the fiscal year 2021, the USCIS Office of Legislative Affairs received 120,000 inquiries. I'm not sure who this USCIS Office of Legislative Affairs is. Probably when the congressman will contact them, but this probably kind of confused me. The office had already received 99,103 congressional inquiries as of April 30th, 2022, which means the agency is likely to receive almost 170,000 inquiries in fiscal year 2022, a 30% increase. So I think the USCIS Office of Legislative Affairs references when we contact a congressperson, contact USCIS, 127,000 inquiries. This year is going to be closer to 170,000 inquiries. And probably most people doing this have lawyers, so they know to even contact them, because a lot of people don't know you can contact a congressperson about this. So this is something important to put out there, just to know that these are kind of out of control. Now, they say the averages when they're doing their analysis of how much time it takes, the averages do not necessarily represent the extent of challenges the agency will face as it works to reach its stated goals in 2 years. For example, the current median processing time for Form I-485 for asylees is 23.2 months, almost 2 years, well above the average for all adjustment applicants. Now, the one thing that's important is the chart here as well that people can see. I should probably zoom in on it so people on the video can see it better. But they always talk about the median time, not the mean. So median is like this different averaging kind of mechanism. So, I kind of wish they would get a mean in there too. For asylum applicants, and I get a lot of calls and emails about this, who file for adjustment status based on being asylee. Those cases are taking forever. I-730s are taking forever too. Just prepare for that kind of stuff and let clients know in those cases, it's not the same thing as a marriage adjustment case or employment based. It's going to take a while. So that's just something that you're going to have to take and prepare for. All right, so some more charts. The next section, the need for more flexibility in renewing employment authorization. So we have the good thing for adjustment cases that are going much faster, but they have charts here. Like in fiscal year 2017, total employment authorization documents based on Form I-485 that are pending were 633,000. Now it's 769. Not too much more, but total EAD applications based on pending Form I-589, it was 480,000. Now it's 601,000. So for I-589 adjustments, those are really pending Form I-589. Those are getting really bad, even though they're supposed to be going faster. So that's one annoying aspect there. Let me scroll through the magazine or the report to find my section. So, okay, the next one is advanced parole, which we went over a lot of the points, just some to highlight here. Advanced parole is a procedural construct. So the inadmissibility section of the Immigration Nationality Act, Section 212D5A, gives DHS discretion to parole a non-citizen into the U.S. for a temporary period on a case-by-case basis for urgent humanitarian reasons or significant public benefit. Parole is a permission for individuals, even those without valid or expired travel document, such as a green card or U.S. visa, to travel to and enter the United States for a specific reason. It is not considered an admission under immigration law. It's very important to note. The determination of whether a non-citizen is admissible, able to enter U.S. on a visa or entry document without the limitation of parole is not the part of the parole determination. Okay, so USCIS, CBP, and USCIS can grant parole on a discretionary basis. However, this part, since CBP is the final arbiter of whether an individual can enter the United States, a grant of parole by USCIS or ICE merely allows the individual to present themselves to CBP for inspection and ask for permission to enter. Advanced parole is not governed by a specific statute or regulation. It is a procedural device derived from the General Parole Authority in Section 212D5A of the INA. The process of applying for advanced parole is governed by the form instructions and USCIS operational guidance. So you see, it's procedural, so it's much easier for them to do things with it, change it. And it kind of goes to the fact that, let's say you have someone, I think, thinking about it now, while I'm talking about it out loud like this, there's an exception that says if you're on an H-1B or an L-1, you don't need advanced parole, you can travel coming forth. And the interesting thing about the H and L is they're dual intent visas. So if you have them and they're valid, you should be able to come, even if you have an adjustment case pending without abandonment. About taking that abandonment consideration out of the place, which I'm not sure why they have to have that part of it, but maybe that's statutory. I'd have to check that out. But let's say you came on a tourist visa, you file for adjustment status. If you leave, potentially your tourist visa was overstayed, so it's automatically voided. So to be able to re-enter, you will need parole for that to find a way to re-enter. So that might be a reason why you would need parole. So that's I'm thinking out loud. Hopefully that makes some sense for people listening. But it is procedural. They can do whatever they want with it. Essentially, it's flexible in that sense. So they should just do it. Here they say that okay. So this is interesting to know. An advanced parole document issued by USCIS can be presented by the applicant to CBP upon arriving at the port of entry. The document can either be a standalone advanced parole document or a combination EAD and travel document known as a combo card. And so traditionally, the combo card was what people would get because they would approve the EAD with the advanced parole at the same time. Every once in a while, rarely, I would have the AD approved and advanced parole issued separately. Nowadays, that's going to be commonplace with the change in the way they're doing this. But when it comes separately, it's like a piece of paper that they bring. But they say its validity period and how often the recipient can re-enter depends on the basis for advanced parole and the type of document issued. An advanced parole issued by a service center or the MDC to an applicant with a pending I-485 under Section 248A has a validity period of no more than 1 year minus 1 day from the approval and allows for multiple entry. So if you get a standalone, apparently it's only valid for 1 year, but if it's a combo card issue with the EAD, it's valid for 2 years. So that's going to create an issue for a lot of people who got the EAD approved and advanced parole approved later. It's going to be valid for 1 year. Now, in most cases, probably the adjustment status is going to be approved within that time, so it's not that big a deal. But be prepared. The advanced parole you're going to get seems to be like 1 year minus 1 day. So that could happen. I just wanted to note that. Okay, waiting to receive the green card before traveling has become less likely as Form I-485 processing times have trended up from the last 2 decades, especially in the last 2 years. The current average national processing time for Form I-485 at all service centers, field offices, and the MDC ranges from 8.7 to 23.2 months. So it's kind of like all over the place, 8 months to 2 years, which is almost 3 times longer than the processing times in fiscal year 2017. So, yeah, I just want to share those numbers with you. It's out of control how long these things are taking. CBP has the discretion to deny entry even if the non-citizen presents an APD advanced parole document and can instead place a non-citizen in removal proceedings under Section 240 of the INA, where an immigration judge would determine their admissibility as an arriving alien, also referred to as an applicant for admission. CBP will also give non-citizen with advanced parole document the option to withdraw their application for admission at the port of entry. So I thought I'd add some technical stuff in there. So you have that. Is APD even necessary? This goes what I was talking about. USCIS may wish to re-examine whether it needs a separate advanced parole adjudication process or a separate advanced parole document card or at all. USCIS grants advanced parole to AOS based on their pending I-485 by applying the employment authorization incident to status structure to advanced parole authorization. Blah, blah, they bypass it. There's no current regulatory requirement that USCIS issue a document as proof of advanced parole. A receipt notice may be efficient. Overall, for I-131 expedited processing requests have almost doubled. So these are people in the advanced parole expedited. I filed several of these. I have some major issues with clients who have sick family members that need to visit, people in the hospital, people who died, people have urgent business need, and it just most of them are getting denied, frankly. So, or you have to go back and forth and several times with them. They don't answer. They say from I-131 expedited processing requests have almost doubled from 10,700 in 2017 to 20,000 in 2021. Similarly, in-person appointments scheduled to address for I-131 emergency advance parole requests have trended up from almost 10,000 in 2019 to a high of 15,000 in 2021. While still relatively quick, wait times for in-person processing at a field office have also increased from 1.5 days in 2019 to almost 3 days in fiscal year 2019. The Form I-131 instructions do not include information on how to request expedited processing for adjustment applicants in the U.S. So this is something if you have a lawyer, yeah, you can do expedited requests, emergency advance for all this kind of stuff, but people don't know that they're doing it on their own. And then to qualify emergency advance parole, applicants must be experiencing an emergency travel need, meaning arising unexpectedly. This is for emergency when you go to the field office. In either case, they must reach out to the USCIS contact center to request expedited processing for the pending request or to schedule an appointment at a field office to submit an emergency advance parole request. Quick side note now for it's here. Now for Expedite, they're saying you need to do the biometrics first, which now it's gotten good for biometrics coming pretty quickly after filing. But there was a moment there where it took months to get the biometrics. So you have to expedite biometrics first and then do the expedite request, which added delays. Going back to the report, the contact center reaches out to the field office to schedule an urgent appointment within 2 days, but applicants have complained of waiting time of days, sometimes weeks before receiving a call back, and our clients, a side note, who never even got the call. So that's that's ridiculous. That's completely ridiculous how the info pass appointment has gone. By the time an applicant receives an appointment at the field office, The desire to travel may still be there, but USCIS may no longer consider the situation urgent due to the passage of time. They're the causation of the passage of time, and then they blame you for it. So it's this like this crazy scenario. Only way I could put it without getting too offensive in a public forum. Individuals and officers face challenges successfully completing the emergency advance parole. So USCIS estimates it can take up to 2 hours to complete a request for emergency advance parole at a field office, which includes receiving a Form I-131, supporting documents, filing fee if applicable. Oh, there's so much going on here I got to talk about. So first of all, it takes 2 hours. Usually it takes 2 or 3 hours, which is true. I went to one appointment in Southern California in San Diego once, and it was done in like 10 minutes. And they were so nice. So like, do you want more time on this? Do you want more than 30 days? I was like, well, what is this place? This is like a dream come true. But usually it takes forever. Then they say a filing fee. This is an inconsistency we're seeing with USCIS field offices where they want to charge you a filing fee for the advanced parole. It's not needed. There's nowhere it says it's needed. You paid it as part of the adjustment of status fee. And I've never had to pay it, but I've had colleagues tell us that in different field offices, they're asked to pay for the advanced parole document and pay a filing fee there. So although I don't think it's needed, to a certain point, is it worth arguing? I don't think so if it's an emergency. So I always tell clients, go with a check, be prepared to pay. Usually I go with them because it's hard for them to do it, but you might have to pay it. And then it goes back to the report, resolving issues with biometrics and reviewing the information various documents, blah, blah, blah. The last step, which requires transitioning between USCIS electronic systems, accessing secure areas, printing the APD, cutting and pasting the applicant's photo of the document, and finally laminating it. Usually the process is time-consuming step. They don't laminate it. They just give you like 4 pieces of paper. I've never seen it laminated before. But that gives you an idea of the process that goes along with just doing the paperwork for it. And then it says, due to the amount of time needed, USCIS does not schedule appointments for emergency advance parole after mid-afternoon to give the officer time to complete the necessary steps. So then this goes to the scheduling issues for advanced parole, emergency advanced parole, is because they only schedule it like the morning to mid-afternoon. There's even less time for them to be able to schedule appointments for it. Individuals are filing additional Form I-131 to preserve their adjust AOS applications. When obtaining emergency advance parole at the field office, individuals could end up with an advance parole document that has less favorable terms than what they would have received on Form I-131 advance parole request processed by the NBC. This is a regular one. The validity period and number of authorized entries issued for emergency advance parole by field offices varies and could be like single entry for 30 days. So one thing I do is I know some lawyers don't do this. It's kind of crazy that they do it, in my opinion, but I always file for I-131 advance parole with the application just to have it going. And if you need to request emergency too, we'll get that. But I actually may get a regular advance parole as well because they may give you only single entry 30 days. So I just want to bring up that note right there. And then improving access to expedite requests. I think it's the last one we're going to talk about that I took notes on, and I was giving away anyway. So that's how recommendations they had is establish a centralized technological infrastructure and specialized personnel to intake expedite requests, and then create a new form for submitting expedite requests similar to the form I-912 request for fee waiver. Develop standardized guidance to the field and to customers about the requirements of the process, and then engage in robust collection data so you know what's going on. They don't collect data on these expedite requests. They don't know what's going on, so it's not good. USCIS policy contains 2 important caveats to how it handles expedite requests. The first is that, quote, not every circumstance that fits in one of these categories, the different categories you could use for expedite humanitarian reasons, government error, blah, 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 will result in expedited processing, unquote. This means that an applicant may establish that they qualify to have their application expedited, but USCIS still may not be able to expedite it. I don't understand what that means, but that's that. As backlogs have lengthened, this situation has become more common. Second, USCIS has stated that in order to increase efficiency, it does not provide justification or otherwise respond to questions regarding decisions on expedited requests. Although USCIS does communicate with customers about some expedited requests, many receive no response. So this is kind of crazy. You make the request, and this happens to me a lot. They never respond to it. They don't know what happened. So you got to call them back and stuff. And many times I call them back. They're like, oh, I'm sorry. We forgot to input the request in the system. Let's do it again. So you got to follow up on these things. Also USCIS does communicate with customers about some expedite requests, but they may not receive no response. After not receiving a response, customers who submit what they presume to be eligible expedite requests often reach out to USCIS again to inquire about the request. This uses more of the agency's resources and frustrates the applicants who is left without any understanding why the request was rejected, especially when they appear to meet the eligibility criteria. So it's a mess right there. An applicant generally initiates an expedite request by calling the USCIS Center or communicating with USCIS online with the virtual assistant Emma. Ask Emma. Side note, apparently this works and it's helpful. I haven't been able to figure out how SM works. I'm terrible at technology, but that may be a faster way to call. Because I wake up so early, when I do call first thing with USCIS, I usually don't have to wait majority of the time. If you call anything past 5 a.m. Pacific time at least, or 4 a.m. or something, it's gonna be a mess. So I used to be very frustrated because I call at like 9. That was a 2-hour wait time, but I don't have to deal with that anymore. Can submit requests in writing to the office with jurisdiction of the case. I've submitted stuff in writing, it doesn't work. I've also submitted stuff with the initial application requesting expedite. They just don't consider it. So the only way I do it is by calling. And then if that doesn't work, then asking a congressional representative to force the issue, and hopefully that works. Ask Emma seems like it works, but the thing about Ask Emma is like you can't submit documents per se. It's a kind of weird thing. So, but it's worth doing for time's sake. Okay, USCIS to lack consistent review process. This is the most frustrating part, which I kind of understand because it's hard creating a consistent process for this. But it says the process for considering an expedite request is confusing, impractical, and inconsistent for stakeholders. Although USCIS reviews expedite requests according to the guidance outlined in the policy manual, the agency currently does not have a single standard operating procedure for reviewing expedite requests. Each officer determines its own process based on resources and duties as they're assigned. So that's a big mess right there. And it's one of those things. Sometimes you call and even on the first line, so when you call USCIS, they're supposed to just take notes and then hand it off. But sometimes you talk to the officer, they seem very helpful. And some of them, they already act like, oh, we're going to deny you. I'm not going to do it. So I've had colleagues say they'll just hang up and call USCIS again if the initial officer on the phone is not helpful, because they're already going to sabotage things for you anyways. And then sometimes you make multiple requests. Sometimes you get Congress people. It depends on who's getting the case. The CIS Ombudsman understands that stakeholders generally expect that once they submit an expedite request, USCIS will direct it to the adjudicating officer reviewing the pending application or petition. Hence, there's a general assumption that if the officer agrees to expedite the case, USCIS will immediately act on the pending and reissued benefit. However, unless they submit their request as a follow-up to an interview or a response to request for evidence, it is rare that the request will go directly to an adjudicator. Rather, in most cases, the requests are reviewed by officers specifically assigned to expedite requests, and they do not immediately send these requests to the adjudicating officer. So it's a little bit backhouse behind the scenes of what's going on here and how bad the system's process is for you. Initiating an expedite request is particularly problematic for individuals contacting the Vermont Service Center or the NSC with Nebraska Service Center. For those who are afforded certain privacy protections, namely VAWA, self-petitioners, UNT visas, the applicants or their representatives can directly contact the visa unit at the service center having jurisdiction over their case. Problems arising, however, when the application is not a primary benefit pending at the unit, but an application pending elsewhere. This privacy protections continue even after the prime benefit is secured. For example, applications or the representatives contacting the NSC Humanitarian Unit hotline to expedite a work permit not pending at the NSC will be instructed to call the contact center, as the NSC does not have jurisdiction over the application. But the confidentiality provisions of these cases prevent the contact center from handling the request. There appears to be no straightforward way to seek an expedite from the agency in these scenarios. Complete nightmare. These are people who are VAWA, U visa, T visa. These are people who need work permits because they're just like going through hell right now. So, that's frustrating. Beyond the caveat that expedite requests appearing to meet the eligibility requirement may not result in expedite, there is no transparency as to which expedite requests get accepted for review and which, even with similar circumstances, do not. Stakeholders have indicated that agency rejects some expedite requests within the same business day, even immediately after receiving it, without providing the requester an opportunity to submit additional documents. Meanwhile, USCIS does not acknowledge their expedite requests at all. So the process is inconsistent, and that's just so important because we're dealing with this so much more. People are needing it. And I think this is the last one right here. The snowball effect of expedite request. Although USCIS does not track all the expedite requests it receives, it did experience a sharp increase in 2021 for requests. Fiscal year 2022 was 63,000. Now it received 145,000, a 129% increase. And this is an important practice note. I have clients who ask, "Oh, can we do expedite requests?" I'm like, it's going to be useless in most cases because they're so overwhelmed, doubling and doubling every year as how many requests there are, that most likely is going to be denied. 5 years ago, 99 every single expedite request I would do, even for weak cases, would be approved. Before Trump came, and then they destroyed that system, and now it's just out of control, where it's like 1 out of 10 would get approved. but it used to be 100% would get approved. So, and not only is it 1 out of 10, it used to be when I get 10 out of 10 approved, I call them and within a week it'd be done. Probably would take 20 minutes, 25 minutes of my time. Now I may have to spend 2, 3, 4 hours on calls, requests, document preparation, responses, congressional inquiries. And it became a whole thing where I used to do it for free for clients. Now I have to charge them because it's a whole thing to do all the work. And then the likely result is very low in approval. So just prepare accordingly for that. Expanding premium processing does not solve the issue. Some have suggested that to unclog the expedite processing, USCIS should consider broadening premium processing and eliminating the expedite process that currently exists. The belief is that those who can pay for premium processing will do so. However, even if USCIS makes premium processing available broadly, financial loss is the reason many applicants and petitioners request expedite processing. These include academic or nonprofit organizations who cannot afford to pay premium processing fees, or applicants who have been placed on unpaid leave or let go from their employment when their EAD expired. A very typical scenario that has been particularly visible for the past few years of backlogs. These expedite request processes is accordingly a necessary option for those who generally need expedite processing to prevent significant harm but cannot afford to pay. Now, with the expansion of premium processing to include EAD in certain kind of cases, they said if premium processing exists, you cannot request a regular expedite request, which it does exactly what they're worried about here. People that have financial situation that need the EAD expedited to get financially fit cannot afford the, I don't know, 2,500, whatever, 1,700, 2,500, whatever the fee is going to be for expedite EAD. So it puts them in a really bad position. Very, very unfair. I don't know how they're going to fix this for EADs being delayed. I mean, for adjustment of status, they did it, but there's other quality things. Now, adjustment of status C9 category, not for the asylum-based category. I think it's asylum C9 as well. I'm not sure. I don't really have too many adjustments based on asylum. But that's it for the 2021 Ombudsman Office Report. Very interesting stuff. The great thing about these reports, it allows you to see behind the scenes what's going on internally, and you see a lot of the mess that there is. In the 2021 report, there's some shocking stuff in there that really took me aback, and I was going to do a whole thing. I was going to actually create a movement to change certain things, and I just got too busy. It never happened. I'll probably go back and review that because it's a lot of important information that I want to go through. Hopefully you listen to the end. It wasn't boring or something like that. There's just so much information here that helps you become better practitioners. So when you're talking with clients, you come from a position of authority of knowing what's going on. And there's a confidence that comes with that. It helps become a better attorney and better business person because of it. Check out the magazine, immigrationlawyerstoolbox.com/magazine. A lot of good information there. Reach out to the authors. Let them know you're reading it. And if you're interested in getting involved in the community I'm creating, outside of Facebook is just a mess the way it's organized. If you're in the Facebook group, which many are, in the Toolbox magazine, I have a page for you to join all these different groups of Facebook. They're good, but multiple issues with Facebook. One is you sometimes read something on Facebook and then you're like, oh, a month later you want to go back to it. You can't even find the search function sucks. And then they don't place it on historical order when it can. They keep changing it. So you're like, oh, I remember it was like 3 posts ago and it's not there anymore. That's annoying. It also doesn't always pop up. It's just up to the feed whether you're going to show it to you or not. And so, I want to create a system where it's there. We can do videos, we can post, it's private, it's internal. And so, yeah, if you're getting into immigration, if you are an immigration practitioner, just want it, it's going to be more generalized information. So it's going to be like beginner to intermediate. I'm going to create separate groups within this software at Circle.so that are like for advanced, like L1 or something like that. I'm going to work my way up because I got to learn the software, but I'm going to create a general community page and do a bunch of stuff there. If you're interested, just email me at info@immigrationlawyerstoolbox. We'll get you in. I think it's going to be a lot of fun to have a community that's private like that. It's going to be a big deal. So thank you for watching. I'll catch you all next week. I think we have a couple of interviews coming up too with some immigration practitioners. So I think it's going to be a lot of fun. Catch you on the next one. Bye-bye.